Lights. Am I ready? Hi, I'm Chip Merlin. I'm glad you could go ahead and join us today. A lot of times when I get in front of public insurance adjusters, I start teaching them about all kinds of crazy issues that really don't have to do with the practical aspects of public adjusting. But there is one aspect I talk about public adjusting, and that is if you're in a state not much is going on and there's a huge catastrophe next to you in another state, why don't you have a license in that other state? And I was thinking about that and the various ways public adjusting has changed over the last 35 years that I've noticed. And I've started to see some adjusters end up, I saw adjusters from Arizona out in Puerto Rico. And I see adjusters going all over the place, some public adjusters that are actually combined to get together so that after a major catastrophe happens in somebody's backyard, they then have enough manpower by pulling other public adjusters from different states to all get together and be able to work together, take care of that person's clients, and all share in the fortunes that might come from the good job that you need to do. And certainly, especially in catastrophe areas, there's a big need for public adjusters. And so, having said that and say, geez, this is what you ought to go do, and pointing it, well, how do you go about doing it from a practical standpoint? And then people start calling me and going, hey man, what about all these various issues that are out there having a multi-jurisdictional practice, and what do I go do? And so man, maybe we ought to have a seminar just on that and start having a discussion. And so I actually, to start this off, I actually asked Holly Soffer if she thought it was a good idea. Holly helps public adjusters all over the United States with respect to setting up their practice, make sure you have incorporation, make certain your licenses are right and all that kind of stuff. And she's kind of the backroom attorney that everybody needs in order to doing it right, and you don't end up getting in trouble with the various departments of insurance. And then who, on our team would be, in different areas. And Renee Sigman heads up our operations out in Texas. She's in the Houston office. She's a fantastic attorney. She's been nationally recognized for developing catastrophe discovery plans for the various lawyers and what the judges are going to follow after every single catastrophe. And she's even just been appointed to a panel that's going to be determining the discovery plans for the COVID, the pandemic claims, the virus claims that we're all putting business interruption and business income and civil authority claims for. She's on that special select panel. And then we have Michael Ponzo, who heads up our operations out in Arizona, is also licensed in California. As a matter of fact, I said, Mike, can you take that California bar exam? I said, there's only a 20% chance that you'll pass it according to statistics. He took it, he passed it on the first time, unlike some other attorneys that take forever. I got lucky too. Somehow I passed it. But I told him in advance what he was going to be up against. So I thought these nomads all over the place from Houston, one from Arizona, one up by Philadelphia, these attorneys could help you out. And I would encourage public adjusters, if you're not already doing, to seriously consider having licenses ready to go in different localities. I think it's just good for you. I think you can make more money. I also think when you adjust claims in different areas, and I've learned this from my own practice of law, you start to appreciate the different rules and regulations that there might be, the different ways of adjusting claims, the rules that apply to adjusting claims, and you become better at it even when you return back to your home state. So having said that, I think my job for this is all over with, and I'll let the three panel of experts go ahead and start in on that. I hope you have a great presentation and you learn a lot from this. Thanks.
Thanks, Chip.
Chip, before you go, I have to say, this is all about making public adjusters better at their jobs. And I've heard you give a speech a few times where you've told the public adjusters to be the Tom Brady of public adjusting. And now he's coming to Tampa, so you must have had a whisper in his ear or something. I just thought that was funny. So yeah, this is about making you guys better at your job and making life easier as you're adjusting claims from state to state.
Okay, so part of this came up because we've had discussions from various public adjusters who'd come to us and ask a series of questions about, hey, I'm working now in Ohio. What's the law in Ohio, or what do I need to do? Or I'm using the same contract in Ohio that I'm using in Arizona. What are my issues? And we really, I don't view myself as an expert in understanding public adjusting. What you guys have to do, and Holly is that expert. So we thought it'd be a good chance to have a seminar, where we actually are going to spend the time today picking Holly's brain about some of the issues you face out there. It's going to be a learning seminar for both myself and hopefully everyone else here. And so we listed some of the states where we're licensed. I mean, Renee is licensed in, I think, New York, Texas, and Louisiana, Renee, or Colorado?
Texas, Colorado, and New York.
Right. And I'm in California, Washington, and Arizona. Chip's licensed, I think, everywhere. But Holly, we've gone through, why don't you give us an idea what we're talking about today?
All right, thanks, Michael. As you said, and if you see on the slide before this, there are 6 states that we're really going to talk about today: Arizona, California, Colorado, Florida, Louisiana, and Texas. And we picked those states because we thought that those were states where public adjusters seem to go from other states when they're either when there are storms there, or just because it's easy for them, or they border on states where they're practicing, or they want to get out of the bad weather and they want to practice in these other states. So what we're going to focus on today is looking at those states and talking about licensing issues, what documents you may need from state to state, how your conduct might be regulated differently from state to state. And then in addition to that, just some general tips about, oh, if you're practicing in Texas, you should know this or that. And that's one thing that Renee's going to talk about later, since he's so knowledgeable about what goes on in Texas. And then we're going to try and give you some tips to also just avoid some pitfalls and maximize your claims, because that's what it's all about.
Okay.
So the first thing that Michael mentioned and that I mentioned is licensing. And if you look at that slide, you may say, well, why does it say 1-46 of 50 states plus DC? And I also just want to mention plus Puerto Rico, because I know some people that do a lot of work in Puerto Rico and in the Virgin Islands. So Puerto Rico does also license public adjusters. The reason it says 1- is that one of the recent ones to pass sort of a licensing bill, that's why I listed separately, is Wisconsin, which isn't the subject of today's webinar, but they have regulation but not licensing, and only for in-state public adjusters. So I'm not really sure ever how to categorize that one. There are some states that don't license public adjusters: Alabama, Alaska, Arizona, and South Dakota. So it's kind of like the wild, wild west in some of them. Some of those states, especially the southern states, you have to be careful, because doing your job could be considered the unauthorized practice of law. Another topic with licensing is emergency licensing. Not all states have emergency licensing. Even states which offer it to insurance adjusters or independent adjusters don't always offer emergency licensing to public adjusters. So you have to be careful about that. And even if it is in the law, sometimes it's dependent upon the insurance commissioner issuing a bulletin saying, okay, now this triggers emergency licensing. You can't just assume and go from state to state. And the next thing seems obvious, but I really wanted to bring it up, and it's in bold, where it says entity license. Right now, I'm in the process of doing maybe 3 or 4 investigations with public adjusters where they've been cited for working in another state without an entity license. Because what happens is, as Chip and Michael have mentioned, you travel to another state, you take as a public adjuster, you don't even have to take a test the way lawyers do, but you get your non-resident license, you get your bond, you're good to go. Then you sign a claim and you use the contract from your business back in your old state. Say you're going to be working in Texas and you're from Arizona. You go and you pull your contract, and even if you use the correct language in the contract, the name on the contract is important. You can't use your company name unless your company also has a license in that state. You can have an individual license and work in the state, but when you go to sign the contract has to be in the name of the person or entity that has the license. And there are a lot of public adjusters that get tripped up by this, that don't realize. They think they got the license in the other state, and then the money comes in, they have their company logo on there, it comes into the company, and unfortunately that's a violation of the law. And it happens a lot. As I said, I'm dealing with a few now, and you'd be surprised how many people are just astounded when that happens.
Hey, Holly, I'm going to interrupt you for half a second. I think we have a typo.
course.
Arizona is a licensed state for public
Oh,
adjusters.
yeah.
I think that's supposed to be Arkansas.
That was supposed to be Arkansas. I just read it off the
Okay.
slide. I had
See,
put
at
the
least
initials,
I know they
and
have to be
whoever
licensed
typed
by a home
it in
state.
here didn't even notice. Thank you.
Did you
It
see
was
That's
supposed to
okay.
be
I just wanted to
Arkansas.
make sure it's Arkansas that has no license requirements.
Yeah, you're right. We put the initials AR, and a helpful person in the Merlin office typed it out for us, and unfortunately, I didn't even notice. So thank you for pointing that out. You're absolutely right.
They don't realize we spent the past hour on sound issues and we hadn't had a chance to do the final check on the slides. So we
Yeah,
apologize for that.
You like your face features. That was funny. We can see what your eyes are doing.
Okay. All right.
Yeah,
Hal, I think you're about to move to Unfair Practices Act.
as you sit there in Arizona saying, I thought we had licensing here unless something happened
I'm going
since,
like, wait a
in the
second.
last
I know
few
it's
days.
not correct.
So we might as well move on to the next slide.
Okay.
And I think one of the two of you wanted to talk about that, but all I wanted to say is that sometimes a violation of the public adjuster law is also a violation of the Unfair Trade Practices Act, and you can get tripped up and end up being even charged with a felony in some states because your violation of the Public Adjuster Act automatically violates that other law. So things like not having the right name on your contract or not even having the right documents can get you in more trouble, unfortunately, than you even realize.
Okay. Oh, our favorite slide.
Yes, as we were preparing, that was our favorite slide. We don't want that to be you, and we don't offer to come visit you in prison if that's the case.
Okay.
So one of the other things that that is different from state to state is obviously not just restrictions on conduct that we'll talk about in a little, but restrictions on fees. There's current legislation in California right now to say that a public adjuster can only charge a fee on what's called new money. So you can't go back and say, I'm going to take, 20% of whatever I get you, or 10% of the total recovery, whichever's less, which I know a lot of public adjusters do. California is trying to pass legislation that says you can only take your fee on new money. There are states, obviously, that cap fees across the board, and out of our little group here, Texas and Florida do that. There are states that only cap fees on catastrophic losses. Colorado and Florida do that. So if you're going to be safe, you have to be aware of this, because very often it's not something that you have to put in your contract, but you can't charge that amount, same amount you may have charged in your old state, or you're going to get in trouble. And then the most interesting state, in my opinion, is Louisiana, where there are no contingent fees or percentage fees at all. So in other words, you have to charge either a flat fee or an hourly rate. You can't charge a percentage fee at all. So that's one of the biggest restrictions. And since we're talking about Louisiana, technically under the law, as a public adjuster, you can't even negotiate with the insurance company. You're supposed to just report back to your insured. And if you do negotiate, consider the unfair practice of law. At APIA, we went in and we worked with NAPIA and other organizations to try and change that. For a while, I had the pleasure of going to Baton Rouge once a month on a task force that was trying to rewrite that law. And unfortunately, we got nowhere. I had a lot of great food there. I love Louisiana. Met a lot of great people, but we got nowhere with trying to change the laws for public adjusters because the Bar Association is so strong there that they opposed us at every turn. And they're very powerful.
Holly, I'd like to add something to this slide for
Sure.
Texas. And this also goes back to the original slide, or the one preceding this, is if you are planning, for example, to go into any state, obviously it's a very good idea to go to their governing agency first. For us, it's the Texas Department of Insurance. They might have a form, a contract that you can use, at least as a starter, right? But if you do not know the laws in that state pertaining to what a public adjuster would need, then reach out to someone, whether it's an attorney, another public adjuster that can at least guide you, because some states, and I will say in Texas, everything seems a little bit more difficult here, and they don't make it easy. There's a lot of hoops you have to jump through in Texas. And so, for example, and I like to tell people this is one of the things I talk about, when I speak at seminars is in Texas, public adjusters, of course, are held to a higher standard, right? A higher standard across the board versus their counterparts in the insurance business. So versus an independent adjuster, versus a general adjuster, versus an insurance carrier adjuster, public adjusters are actually held to a higher standard in Texas. And they have specific criteria. So if you're getting your license, there's an application. You have to be, honest about everything because they require you to be trustworthy and a moral character, right? And that's a very broad definition. What is moral character, right? What is trustworthy? But one of them is in criminal backgrounds. So in like criminal backgrounds in Texas, you cannot be convicted of a felony in the 10 years preceding your filing of your application. So, and a felony in Texas could be anything, you could be drinking and driving. It could be something else. It could be something minor or a lesser offense. But, there's also some ongoing duties that you have to report. What if you get your license? What if you then commit a felony? Do you have to inform Texas Department of Insurance? Do you have to let people know? But they require, and it is very detailed and codified, certain things. So, and as you were saying on restrictions on fees, and I would say this, if you come to Texas, be careful of who you associate with. If I have anything I have learned and I've seen, is if you're going to work with a contractor, for example, then make sure, right, that you don't put yourself on some target list, because there's lots of lists, there's lots of targets here in Texas. We like to legislate things in the sense, and people like to change the law every 2 years to fit their agenda, usually not pro-consumer, usually not pro-insured, very pro-insurance carrier. And there are targets on contractors in the state. There are targets on public adjusters in the state. So go to a reputable person if you want to practice in that state before you decide to hitch your wagon. Because it could save you a lot of headache later on, because you probably won't intend to break the law. It'll be by accident and just by lack of knowledge, but it'll be a lot of headache you have to deal with. So, as for the fee cap in Texas, prior to 2005, there wasn't a fee cap. After 2005, the legislature changed, everything changed, and the fee cap is at 10%. And it's 10% of the settlement of the claim. Now, what's interesting, and this is one of those little side notes that I talk about, is there's a lot of contracts that are out there that talk about being able to charge 25% on an additional payment, for example, or supplemental payments, and then not to exceed 10% of the settlement as a gross, right? I think there's a little gray area. I will tell you, the insurance carriers, their carrier attorneys are very watching those type of contracts. They don't like those type of contracts. They think that they violate the spirit of the law, which is a 10% cap. I think you will find yourself having to explain as a public adjuster, for example, if you do take 25% on the beginning part of a claim, and let's say you anticipate you have $1 million estimate and you take 25% in the beginning of each of these payments. Well, let's say what happens if they don't pay your estimate at the end of the day and the case settles for far less than you thought, and you took 25% in the beginning, of course, with the notion that you wouldn't exceed 10% of the gross. But what if at the end of the day, it turns out that actually that fee was in excess of 10% because the case settled for less? Well, that leaves a question. Do you have to return your part of your fee? Do you have to comply? So my point is, just be careful of what you do and know that it's under a microscope in Texas. And there's a lot of unfair targeting in this state on the insured side, the carrier side. So, know the law. If you don't, reach out to a lawyer that knows the law, reach out to a public adjusting company that you may work with, and be careful who you associate with in this state, because you will find yourself possibly a target, not intentionally. So.
Everything that, that Renee says is good advice. And it applies to other states as well as Texas. She's right on with Texas and she's there, so she's the expert. So I would listen to exactly what she says. And it's true, Florida's on our list. Chip, knows since he's in Florida, what kinds of attacks there are in the public adjusting profession and restrictions on trade in Florida. So it's everywhere, and what Renee said about reporting is really good advice as well. When you travel to these different states, if you say forget to use your entity name on your contract, so you have an administrative violation, say in Florida, and Florida says, okay, we're fining you $500 and go on your merry way, and then you're also licensed in 10 other states, some of those states will say, okay, you just have to let us know that upon renewal of your license, and they'll ask that question on the renewal form. But others will say, no, you have to let us know within 30 days of when you receive that administrative investigative action or at the end. So whatever the result was, you have to notify the other states sometimes within 30 days. So if you don't find that out, then all of a sudden you find you're in violation of these other states. And then it just builds and builds and builds, and you can eventually lose your license in those states. So it does get tricky, and you really do have to know the law in each state. And I'm actually not happy to hear about how tough Texas is, because I didn't really know all that going into it. I thought some of the other states were bad, unfortunately. So
well,
in terms of
very unfounded. I will tell you, I'm a big staunch advocate against it, but I feel that our agency here could do more for consumers and insureds, and they have their guns aimed at the wrong target and the wrong side. So, it is, but it's a reality we live with right now in this current climate. And so it's just be very careful and reach out to somebody to save you headache later. But it is what we're dealing with right now.
It's true. It doesn't cost much to consult an attorney and get a contract written, and we're going to talk about that next for letter of representation. And what I usually do for clients is, if I do your contract, I'll give you another page with pointers on how the law is different in that state. So it'll say Texas, for example, fee cap, is there a ban on solicitation? Do you have to do your contract in duplicate? Is there a rescissionary period? So some of these things that you're looking at on this slide, find that all out ahead of time, because it costs a lot less to do that than to get yourself out of trouble in the end, because not only will you have legal fees, but you're going to have fines with the department, and you could even lose your license or get suspended. So I just mentioned a few of the things that different states require for these contracts, and I'm not going to go into and bore you with the details of all the contracts in the 6 states we're talking about, but just know that some states, there's a form, you just fill it out, send it in, you're done. It's very easy. Others want to see your contract ahead of time, maybe when you get your license, or some just later if you change it, they have to approve your contract. You have to put, Texas is really big on all the disclosures and notifications about conflicts of interest and other consumer rights. Florida as well. Florida has a lot of disclosure. Some states require you to do an expense outline called a list of anticipated expenses. Some you have to check off if it's a catastrophic loss, because that might change your fee arrangement or your rescissionary period, or just even your notice with the insurance companies. You have to put in, the rescissionary period. Just because your state law doesn't say that the contract can be rescinded in 3 days doesn't mean there isn't a rescissionary period, because in the absence of that, the federal law applies for door-to-door sales. So that's something that a lot of people don't know. And do you really want to be litigating later whether they solicited you or whether you came to their house to solicit them? So if you see nothing in the law, assume it's 3 days. And then attestation language is just saying that you're bonded and insured. And that's in a lot of the states as well.
Okay. How about letters? Go ahead.
Yeah, and here's like a little summary. As I said, Michael's lucky that he works in a state that's pretty standard. Arizona's laws are pretty standard. Again, we're not going to bore you with all the details, but you can just see a list of some of the little things that you have to worry about for each state. And I'll just mention briefly, California's new proposed legislation is not just talking about fees, but there's another little tricky part that says that now in your contract, you have to specify what exact coverage that you're going after. You can't just say, my job as a public adjuster is to advise and assist, on the negotiation or settlement of a claim. You have to say, I'm going after coverage A, or just contents or structure. And if you're not specific, then your contract is invalid. And if you don't list everything, you can't pursue that aspect of it. And that's something that's definitely going to pass, that part of it, once the legislature resumes. Again, Colorado has those lists. It's really easy to make those up. I have a form for that. Florida, you know, there's so much that has to be in that contract. Louisiana, again, you can't put a percentage fee in. And Texas, I'll leave to Renee, but there's a lot of stuff that has to be in their contract.
Yes, Texas, of course. Texas, you can see just by how many words are on that slide. And I was going to say, Chip, you probably can chime in here, because I know you and I, we get hit by opposing counsel we will not name that talks about these issues regarding contracts that allow for 10% of the recovery, right, RCV, versus getting paid 10% of the ACV, which would be the payment. And it's a hot topic in Texas. I'm just saying, it is really, it's crazy in that sense. And we hear about it often from the other side. He'll email and say, you know, there shouldn't be any 10% of the RCV, because what if the client doesn't do the repairs? What if there's depreciation withheld? Should the public adjuster get 10% of the RCV versus 10% of the ACV, which is the actual payment?
And the actual payment would be the RCV. In other words, there's a model law, the NAIC model public adjuster law addresses this, and it says that as a public adjuster, you get your fee as a percentage of each check that the client gets. So if the client doesn't get it, you don't get it. And basically, that's the golden rule. And if you do that, then you won't be taking money that you're not entitled to. So every check that comes out, you take your fee as a percentage of that check. And if you really did work to get them the depreciated amount and helped, then you deserve a fee on that. But if you didn't, then you don't. There are some other issues too about whether you should take your fee on ALI. But really, Renee and I were talking about this yesterday. If public adjusters don't follow the rules and the department wants to institute new legislation to say, you know, a public adjuster has to take a fee as a percentage of each check, which would be fine, that opens the door to them throwing in all kinds of other restrictions against public adjusters. So if everyone does what they're supposed to do, usually that will help avoid bad legislation.
Now, Chip, you were going to say something about this topic.
As soon as I get unmuted, yeah, there we go. Yeah, somebody shut me up the computer. Yeah, it's what I found and what I worry about, especially for the traveling public adjusters, is that when you go to another state, you get licensed there and you're brand new, don't kid yourself. The departments of insurance know you're coming in from a different state. And it's just been my observation that, especially after catastrophes, the first people they tend to pick on over and over and over, out-of-state public adjusters. And it might be for charging too much, for having the wrong contracts. Those are probably the two main things, and Holly can talk about it probably more than me, but at least when I'm looking at cases, people are in trouble for this and that and the whole bit. I would be very careful when you go to another state, find the leadership of public adjusters in the various states you go to, ask them what their contracts are, ask Holly what your contracts are, make certain you're not overcharging on certain things. There are some states that will absolutely light you up and you are not going to pass go. You're going to get possibly your license taken from you. And just as Holly said, once it goes in one state, you got to let all the other states know just what happened. You might not be practicing public adjusting. So especially on those two things, contracts and what they say and what are in them and what you're charging, it's just been my observation that those tend to get, you know, I don't know, the regulators regulate those from out of state a lot more, and the new people on the block, they don't necessarily trust you. That's just the way life is, and be very careful.
Mm-hmm. And not that, if public adjusters from out of state continue to use the wrong contract and not follow the rules, then that often leads to a punishment of the whole industry in that state by the Department of Insurance trying to crack down on that by overreaching and introducing legislation that hurts all the good public adjusters who are following the rules. So it's really important to not make it worse for the whole profession by just not following a silly rule that, you know, aside from the fee cap, some of the other rules are just disclosure. It's just a matter of cutting and pasting something and putting it in your contract, and then you're compliant. It's that easy.
Holly, I had someone text me a question during this webinar, someone watching the webinar. And I'm going to pose it to you or whoever on Louisiana, because it's about Louisiana. The question is, so if we can't negotiate in Louisiana, can we just charge our hourly fee as part of the claims prep portion of the claim?
I'm not sure what that means. I mean, I put it this way. The law says that to negotiate is the practice of law. So it's really unclear what public adjusters are supposed to do. The law says you're supposed to report to the insured. In practice, every public adjuster negotiates. So, and I haven't heard of them prosecuting people except for, I won't mention names, but there was a famous case a few years ago where they were accusing public adjusters of doing that. So if the question is, what can you charge? Yes, you can charge a flat fee. Yes, you can charge an hourly fee. And, you know, in a sense, it's tough because you're trained as a public adjuster to charge a fee depending on the size of the claim. So when you go in to do the estimate or to go in to meet with a person, you probably like look around and see what you think it's worth, or you can charge hourly. And, you know, sometimes it works out worse for the insured when people are charging hourly because the hourly rates are so high. I think the Department of Insurance may be a little short-sighted in that people will probably be charged less if there was a percentage than charging an exorbitant hourly rate. I've seen cases in Louisiana where public adjusters have tried to charge as much as $600 an hour, but then it ends up coming in front of the department. So yeah, I mean, you can certainly charge an hourly rate. Just be careful that it doesn't end up being 75% of the recovery when you add up all your hours, because that's something the department will definitely look at.
Thank you, Holly.
Thanks.
Sure. So, you know, other things other than contracts, as we mentioned, some states have a ban on solicitation. Some of the ones that are in our programs, Florida has one with certain hours, certain days. Louisiana has a lot of states have a ban during a loss-producing event. California has a ban on solicitation during certain hours. Texas, of course, has one. And other examples, things like advertising, something you might not really think of. Say you work in 10 states and you hire an advertising company to put out a postcard for you after a storm in those states saying, call us, or do you need a public adjuster, or just saying what a public adjuster is. In some states, they have specific rules like Florida does on advertising. You have to have your license number. It has to be in a certain font. It has to be a certain size. So you can't just assume that what's good in one is good for the other. Rescission time periods, again, are different in every state. Most are 3, some are 4, some are 2. We can go to the next slide. And, you know, as there are things other than legal things that we can talk about, like policy interpretation rules. That's something that's different in every state, and you really have to think about it. When you practice there, you want to know what's the rule on matching here? How is it different than my own state? You're just not spinning wheels, wasting your time making arguments that aren't going to get you anywhere. What's the definition of surface water? Chip did a blog about that the other day, about how it's different in every state. So things like that are important to know. Estimates, some states say you have to copy them to the insured. The settlement has to be in writing. Escrow accounts, statutes of limitations. And that's something where I'm going to refer back to Michael and Renee, you know, why it's so important to know the statute of limitations before you start negotiating the claim and how it's different.
Well, this is a big concern because this is this basically ends their rights. And, you know, sometimes there's a clause in the contract which limits the timeframes. And we get very, very nervous when something comes to us, you know, a year or 2 years into the adjustment, and now they want to move forward. And it really will depend on what actions were taken and how the adjustment process went. What is the you know, as Chip says every time, did you read the policy? What's the policy say? So, you know, I would recommend that, you know, fairly early on in a case, if you think it's going to become contentious and during adjustment, it's a good time to start getting advice from a local counsel on these statute of limitations dates, because, you know, we don't, you know, you got to be very careful. We can't generate a quality complaint in a week. Okay. So it's very, very difficult. You know, we don't typically, at least for my practice, I don't typically like to have get anywhere near the statute of limitations. I like to have at least 6-month window plus on it. I'm not sure how Renee goes, but there are a lot of issues to consider. Renee, how's your life on statute of limitations?
Yeah.
She wants
Well,
to try before.
well, we have carriers that try to enforce statute of limitations that are lower than 2 years. But typically under the insurance code, you'll have 2 years and a day, and then you can argue sometimes discovery rule, that depends. So is it from the date of denial or the date of underpayment versus the date of loss? Insurance companies didn't like that after Hurricane Ike. I'll tell you, during Hurricane Ike, sometimes people didn't file their claim for over a year past the date. And you could file a claim up to almost 2 years past the date of the loss and extend your statute, if you can imagine, almost to be 4 years from the date of the loss. And carriers didn't like that. So what do? They changed their policy. We have so many changes in policy here that you'll now see these, what I call bookend policies, that say you have 2 years from the date of denial or underpayment, but at max you have 3 years from the date of loss. And because they don't want late file notice claims in order to open the statute back up again. So and then you have the commercial policies, of course, and that are very controversial with the arbitration clauses. And is your arbitration clause one that it requires you to abide under New York law and procedure? Is it substantive, where they're applying New York law, even though you're in Texas, or is it more of a procedural thing? These are things, honestly, I would tell public adjusters, one of the things you need to do first is read the policy. But read it for a couple things. This is a quick tip. Read it for the appraisal language. Read it to see if it has an arbitration provision, and read it for the SOL. Because you will get in major trouble if you just read the policy limit deck page, some of the things that apply to claims handling, but do not keep going in the policy defined. As I would say, look for suit against us. That's language terminology. Look for appraisal and look for arbitration. Always, because that at least will keep you out of hot water for being sued if you blow a statute. So
good advice. And sometimes it's tough to understand, the differences in all of those legal principles. So it's really good to check with someone like Renee if you're not sure about a specific policy or a specific state. Or Michael, sorry.
Okay.
One of the biggest differences from state to state, and one of the most controversial issues, and if you were at the FPCC meeting in Rhode Island in October, when we were talking about this, I was doing a presentation. This was such a controversial issue. People were yelling and people got feel really passionate about this. So and what I mean by conflict of interest is whether you can be a contractor and a public adjuster at the same time. There are parts of the country where that's the standard, that's the business model, like in Illinois. And there are parts of the country where it's specifically prohibited, like in Ohio, where it's really, really limited. So there are a bunch of states with no restrictions at all. Some it's completely prohibited. Some you just have to give disclosure. So if you split, if you go to the next slide, you'll see a really pretty map. And there was an intentional effort not to make them red and blue for political reasons. So these are red, green, and yellow with, obviously, I don't know if you can see the key if it's too small, but just use common sense. The red means it's prohibited. The green means it's allowed. The yellow means it's there's some restriction. The gray states were states that didn't license, and I can't even read my own key because it's too small. So some states, public adjusters are called something else, like insurance consultants. So those are some of the other patterns on there. So this just gives you an example of, if you look, there are a lot of states that are red, and that's growing. So that trend is growing toward public adjusters not being contractors at the same time. And again, if you look, yeah.
Holly, I have another question that came through. I kind of like this.
Okay.
I'm getting little text messages of questions, but I think these are good ones to ask you or anyone who can answer this question. But here is an interesting one. Does every state, or is it required by any state, that a written contract be in place for every claim? So for example, do you have to have a written PA contract on every single claim in all states, for example, or can you have an email agreement for your fee and maybe not a written contract in some states? Or do all states require it in writing? That is a question.
Sounds
Will
like
an
a lawyer
email
wrote.
suffice? Does an email
Sounds like a lawyer.
does an email basically agreeing to the fee suffice in some states, or do you actually have to have a formal contract in most of these states?
Well, yeah, as I was saying, and I'm sorry, there's a delay where I couldn't tell if you were
Yes.
still speaking. Some audio problems we were having, but I said it sounds like a lawyer wrote that question because it's long-winded. But
No, it was me.
and this
That
is
was
the
me.
answer.
Long-winded.
No, I think lawyers always try and find the angle. That's, not just that. The lawyer's trying to find the angle, but the answer is in states that license public adjusters, some states just say there has to be a written contract. Most states say not only do you have to have a written contract, but it has to have certain terms in it. And you have to have, lots of listed terms. So I suppose if your email were long enough to cover every single term that was in the contract and the other person signed it, and so the insured has to sign, not just that, even if the law didn't require it, it's a bad idea not to have your agreement spelled out in writing. All four of us on this panel as lawyers would advise any client not to take on something like that without everything spelled out in writing. But if you're saying, I don't like that contract, and that's required by that state, it's really dependent on that state as to how specific it has to be. But every state is going to require something in writing signed by the insured is the short answer. I saw Chip wanted to say something.
Go ahead,
It's
Chip.
not only that insured, it might be all the insureds. Since you only got the contract signed by one insured, is it valid against all the insureds? I could hear these arguments going on. I don't know any public adjuster that ever does a contract in email. It's kind of a crazy, I guess whoever wrote that question, but it's like oral contracts are valid except when you have state laws that prohibit them, and there's some law that prohibits it. But as a general business practice, you're just crazy to ever have so say this is a valid contract that's confirmed in an email with a policyholder. So, good luck on that business practice holding up. So.
Well, I'll add something though. As we go towards a more electronic practice, right? We're all in COVID land and we're all on this Zoom webinar instead of in person. I am interested in seeing how this evolves in some cases. You may, right? You can send things through DocuSign and electronic signatures and emails like that. I think there could be an argument. I'm not saying, but there could be an argument if you contain every single thing that you're supposed to have under the law of that state within an email, for example, where that could be seen as a contract in and of itself. Could email responses that are verifiable to a server address could constitute a signature? I think we will see some evolution as we all remote more. Because who would have thought that, shoot, I've got 3 kids and are you kidding me? We got to remote learn. I would have never thought I'd have to ever remotely teach my kids via Zoom or staying at home, as you all guys, everybody knows. But the reality is people are thinking it's okay to educate this way and this is sufficient. So, well, maybe a topic in the future at some point.
Yeah, here's the thing. The DocuSign agreements, I've written a lot of those for public adjusters. Some of the language in there when everyone was starting to stay at home in the end of March. And the difference between a DocuSign and an email is in a DocuSign, you're saying in there, I consent to use this as an original signature, and I'm aware that this email will constitute my original signature on the document. So it meets the legal requirement of you executing the document. And that's in the DocuSign agreement, and you have to click that before you get to the body of the contract. So regular email, I don't know. Under general contract law, of course, it would be a meeting of the minds, like you're saying, if both parties agree, and if the contract contained every single term. But I think the difference with a DocuSign is you're explicitly agreeing that this constitutes your original signature, since the statute does say you need an original signature. But what's next? We could do a Zoom contract. What about that if you read the contract out loud to the person? With the technology, different things are possible.
I don't know if I don't even know if that's needed in the sense of why I say this is COVID's obviously right now has restricted people from meeting in person and getting signatures and doing stuff. But I can tell you in the practice of law, for example, sometimes me and opposing counsel just via email will say, we agree that this email, is a contract under, rule 11, or it's a 29 agreement, and just by our responses, right? And I'm wondering, again, it's more of is it a legal requirement that you have a written signed contract on every claim?
Yeah, there is. In most states, and virtually all the states, so in virtually all the states, you got to have a written signed contract between and every state's, not every state, but a lot of the states are different. I would not try to sign one more time. Renee's suggesting these things. That might be time between attorneys to make stuff. You public adjusters out there don't want to make a lot of money, not get in trouble. Do not hope that your emails to a policyholder confirming that this was our discussion is going to go as a contract, period. It's a bad idea. Nobody should do business that way. It'd be like an attorney trying to have a contract that way for contingency fee. It would be stupid for an attorney to try to do it that way. We don't do it that way. You shouldn't do it on your contracts either that way. That's just how I feel about it. So I think it's kind of hypothetical, to be honest with you. Again, I've never seen a public adjusting firm, do it that way. And I would, while you can send obviously the contracts via email to sign, and
Right.
certain DocuSign's great, and I agree 100%. All that's changed around. You don't have to be there in person, I don't think, to do it in most states. You just got to be able to get it to them and somebody sign it. And it's like some buddies might have to sign it too, with authority and everything else. And so, and we can get into the minutia, but like getting your contract signed by a condominium association, that's going to be a valid contract, is something to consider, because typically you've got to have the majority of the board. They got to write it down. They got to have notice and all these other things before it's a valid contract. And so again, contracting and doing it right can get you in trouble, and charging too much can get you in trouble. With most departments' insurance, do it right, be safe, don't get in trouble. I want you to go make a lot of money and not get in trouble.
Okay.
Well, and Chip, I'm just the messenger here, and I am playing the moderator of asking these questions. But what it's funny is, right, should be, you're right, the best practice is to have a contract and do all that. What I am interested in seeing is, as we go through this uncharted territory, and for example, in Texas, this is lovely. In Texas, we have courts that are wanting to open up everything and trials start back and juries. But we also have judges that are saying you can try your case via Zoom, which we all know is absolutely crazy, to a real trial lawyer who has to pick a jury and know the body language of a jury. And as we know, on the one that happened here on a Zoom trial, the juror got up and took a phone call and walked away from the Zoom meeting, all on camera. So, I've seen some crazy stuff happen recently. So it wouldn't surprise me that this would be some topic eventually as we go towards an electronic age.
Yeah, but my point is not for the people that are watching this webinar, and not for the people that want to be smart and make a lot of money and not get in trouble and not be controversial. They'll be under the radar schemes, putting their money into the bank. You guys know what to do, because we're telling you the right thing. Let the other people. There's this old story I used to say. My father came back using the Coast Guard, and all the big penguins down there in the Antarctic, they got to jump in the water at some time to go after the fish, and they'd all flock together and be thousands of them, and they'd stop right at the edge of the ice and stuff like that. But some of the guys in the back keep pushing forward, and boom, there's 5 or 6 of them into the ice. The rest of them drop back a little bit, and then they wait. And if there's no blood and guts coming up, and if the sharks aren't eating them, and the whales and stuff like that, then the rest of them jump in. So let the other guys get in trouble first, and if they somehow are successful, you can go do it too. Until then, just try to do the right thing and be smart about your business. Most of you are, and that's how come I'm when I hear things like, oh, maybe we can go do this. Yeah. Maybe you can go do it, but I wouldn't do it. And you guys that want to make a lot of money, you won't do it.
Okay.
Exactly. And honestly, what are the chances of you're getting every single required term that the insurance department regulates in your email? And if you're putting in every single word, why not just use a contract? It's a lot easier, and it's required by law in almost every single state. You know, the states that don't license public adjusters, maybe send an email. But Chip's right. We're here to help you to try and maximize your practice, to get the most value out of every claim and your practice. So you should do it the right way, and then you can just go and be a public adjuster, not have to worry about all these things like documents and wording. You know, you do it the right way, and then you're finished. Peace of mind.
Well, I want to give a shout out though. This is what I'm saying to every public adjuster out there. If you have a question, ask it. So that was the proper thing to do. You may not like the answer, or you may not like certain things. But at the same time, do not be afraid to ask a question. If y'all have obviously people have my cell phone, so they can text me anything they want, and I'm not going to disclose who they are. But my point is, I want the questions. Ask the questions. That is what you need to do. And that's what this platform is for, is to ask so that you can get directions, because it doesn't mean that you're stupid or you're doing something illegal or something's not right. Because there is a practice that people do things like this, and they don't do it with malice or ill will. And our advice is to guide you away from having people on your butt, so to speak, right? Or the really bad counsel that wants to go after your license, or someone who wants to put you in the media for doing something you didn't intentionally do on purpose.
Or after you bust your butt, you spend all this money, you do this thing, and you've done it in a faraway place. They say, "Oh, sorry, man, you ain't got a valid contract up here because we did it in email." So, you know, I mean, everybody's nice to you and stuff like that until you show them the money. They say, "Thank you, no, I don't want to pay your fee." Not everybody. There's some people like that. I'm just, when I hear things like that, it drives me nuts. And I just want to make, as I say, we're here to help protect everybody. Wrote that question, and good for you. If you have some more questions, don't worry. We won't say. I have a lot of questions and I'm wrong all the time. So, but I've learned by being wrong by asking a lot of other people, and they go, "Chip, that's stupid." And
that's a great point.
I'd rather be stupid and put money in my pocket than thinking I'm super smart or afraid, and next thing you know, I'm in trouble.
Well, and that's a good point, Chip, on the sense of all of us get the clients sometimes that want to, after you've done a great job on the claim, gotten them 10 times more than they would have ever gotten before a public adjuster was involved. And they see that you're getting a large percentage of that final check, and all of a sudden they don't want to pay your claim, right? They don't want to pay your fee. It's much easier to enforce a contract in writing signed by them with all the requirements, so than it is to enforce something else that doesn't meet that, to where you could possibly not get a fee at all. So that is probably the most important part, is you want to enforce your agreement. So in case a client tries to wiggle out of paying you for the work you've done, they can't.
That's a really good point, and it's not just public adjusters, but contractors as well. Very often the law will say if your contract is deficient in some way, that it's not valid, in the sense that, yes, you might get paid what the court decides is a quantum merit fee, where some judge decides the value of your work, not the fee that you set out in the contract, which really reflects the value of your work. But yeah, just back to the other point, my son is a teacher, middle school teacher actually, and he always says, you know, the way you learn is by asking questions, and the best students ask the most questions. So whoever asked that question, it really sparked an interesting discussion, so thank you.
Okay. I think this is Renee.
It's all right.
That's just a game.
Lovely. Well, talking about COVID, and I'd be interested to hearing from the public adjusters dealing with this out in the claims handling. I hear from the ones that I work with who have claims, and I am kind of curious as to whether it's spilled in. Are you seeing a trend? Number one, are you able to get your inspections done? Are the insurance adjusters giving you excuses that they can't come out there in person, they can't do their inspection? I will tell you, I have seen an influx of claims come across my desk of carriers not paying post-COVID, all kinds of claims where they've stopped the claims handling process. There is a great lag in ALE on some claims, the Dallas tornado cases, for example, that hit last October. I'm seeing a bunch of those come, and public adjusters who are telling me, look, I cannot get anywhere. They're slow playing the ALE to the point of people having to be, you know, leave the ALE rental properties because they're waiting to the last minute, and slashing their ability. And I think we are going to see more claims because of COVID in general, and that's on the property side. I will tell you, if you are a public adjuster and and I'd like to hear, are there public adjusters that are handling the business interruption claims? Because, there are business interruption claims, and I have told people, you've got to read the policy. They are policy intensive. That is the bottom line. I mean, it is basically, what kind of policy do you have? Do you have the ability to get business interruption? Do you have to show a physical loss or a physical damage to the property itself? Or do you have a good civil authority order that talks about having damage within a radius? And I've seen 1 mile radius, a 3 mile radius, a 5 mile radius. Where your property is located makes a huge difference as well. If you're in the middle of a medical center and you've got a hotel down there and there's confirmed COVID cases across the street, well, you probably have a really good claim, right? But the question is, do you have a virus exclusion? There's a lot to be said there, but this is a hot topic right now. There are a lot of lawyers who are trying to, and I'll tread lightly here, but we've got a lot of lawyers trying to get into that. We got a lot of mass tort lawyers trying to get into that. We got a lot of class action lawyers trying to get into that. But it all stems from the policy and what's going to be interpreted. And just to say, different states think differently. So there has been some bad law that have come out in rulings out of the Southern District of New York. There has been some potential good law coming out of Pennsylvania and Philadelphia. There are other areas that we are watching and on top of here at the firm, watching very carefully. There is a movement for a multi-district litigation that will be heard in Boston on July 30th by the panel that decides whether these cases will get put into, or these claims into, a multi-district litigation. And if the court says it will, then the question is, how many will you have? What state will they be in? Where are they going to come out, and who's going to be appointed the judge? And you have class actions competing with those as well. So one thing, if you are actually picking up COVID claims and you have business interruption and you need obviously an ear to ask questions on, obviously call us, but because we'll be able to tell you that policy interpretation in the cases that are coming out in the rulings from the court, but also know it's going to be a very financially intensive damage model, right? Because you're looking at multiple factors from, what is their loss of business? What is the business interruption? Did they have full interruption where they were closed down completely? Or did they have a limited access? There will be legal arguments as to, is limited access a shutdown, right? Does that qualify under civil authority? There's lots of intricate moving parts, but to not mention it in this webinar would have been kind of like not talking about the white elephant or the pink gorilla or whatever you want to say is in the room. But the fact is, it's there. And it's very much, as you know, you've got COVID claims now with business interruption. You've got riot claims now with other things. I mean, the claims world is evolving. And if you have questions on whether you want to get into that, maybe as a public adjuster, do you want to do business interruption claims? Is there a path for you there or not? Reach out to us, because this is something that obviously is a new territory, but we are seeing different things in different states.
Yeah, absolutely. And Renee, just a general thing, could you explain? I mean, I just got a text on this issue. I finally got one, but multi-district litigation, can you give a brief description of what that is? Because I don't think people understand the difference between that and a class action.
Okay, so multi-district litigation is if you often are, if you're at night laying in your bed, you watch late TV. I don't know how many of y'all do that out there, but you'll see these commercials about Zantac, or you'll see commercials about Roundup. Have you suffered from Roundup? Do you have lymphoma, cancer? Do you suffer from this? Cymbalta. A lot of what you'll see is pharmaceutical drug type of related cases get pulled into a multi-district litigation. So far in federal court, there's not one federal MDL that has ever been granted on first party insurance type litigation in the United States. However, I like to say this, guess what? In Texas, we have MDLs. So in Texas, we like to do things a little differently. Our state has granted MDLs, and the MDLs have been requested mostly from carriers such as State Farm, or Farmers, which has a current Farmers MDL. And what that means is, for example, anyone who's familiar with practicing in Texas, when you have a farmer's hail claim, anywhere in the state of Texas. It could be in Del Rio, it could be in Dallas, Amarillo, it doesn't matter. It can be in Hidalgo, Houston. If you have a hailstorm claim that is a farmer's case, when you file suit or when they decide not to pay it due to marring or a cosmetic roof exclusion, you file your case and you have to bring it into the multi-district litigation, which is a consolidated lawsuit, so to speak, a procedure where all your pretrial discovery, all your motion practice, everything is done in a multi-district litigation in one place. So for farmers, it sits in Houston. So the farmers MDL sits in Houston. One of the former judges is one of the panel judges. There are two other judges, one from the Dallas area, one from South Texas area. It's a 3-panel judge panel, and they make decisions regarding discovery, depositions, motions, everything up till the point of trial. And when the case goes to trial, it's released and it's tried in the county it sits in. But if you can imagine, it could be controversial because it's a perpetual MDL. For the rest of our careers, when a hailstorm happens in Texas and it's farmers, you're stuck into the MDL. And you don't have control of your case when that happens. And so what happens is, you know, you're dealing with judges that are not in your venue, right? Or you're dealing with different things you have to come across. So a multi-district litigation, there have been law firms that have moved for one to cover the COVID claims on a national basis. And thus far, there has never been a MDL in federal court. And when I say that, the ones in Texas are in state court. There's never been a federal MDL nationwide to address insurance claims. So if they do grant one, it will be the first time ever in the history.
And it's pretty controversial. A lot of consumer groups are opposed to that. And before we end, I just want to give a plug. If you want more information about some of the COVID-19 claims, I know that I, as well as the Merlin Group, are sponsors of United Policyholders, and United Policyholders website has a COVID-19 library with all the current legislation, all different lawsuits that have been filed, including some pleadings, and even scientific articles, so you can get some scientific data to try and make your claim better. I know that there's a representative of the Merlin Group on that committee that needs to set that up. It's none of the people on this panel, but you know, we're all working. As Renee said, it's, you know, these issues are national, and if you want some information to just get some background as to whether it's something you want to pursue, in addition to calling Renee, you may want to just look at some of the things on the website that might be able to help you out.
And I will say, for the COVID stuff, we just had a committee, and Chip did mention it earlier, but there was a committee of 10 set up. There are 3 judges across the nation, 2 here in Houston, Southern District Court, 1 out of the Southern District Court of New York, and 7 of us attorneys across the US. And on the defense side, there's like 4, and there's 3 plaintiff attorneys. And we have been tasked with the judges to come up with protocols that would apply in federal court to address these COVID claims that could be adopted by state courts as well, in order to get on top of this wave prior to any type of JPML hearing or MDL, in hopes that, let's say you have a claim and it goes to litigation, there will be guidelines, protocols, standard procedure, discovery things that you can exchange in an effort to narrow the issues to resolve it, right? Because the goal is to get it resolved as soon as possible for your insured. So, you know, we're going to duke it out. Some of you know, I've been on this before. Badger's on the same one too. So Stephen Badger was on the last one. Him and I are on this one too. So there will be a lot of hot discussions, fighting for the rights of both of the parties on all sides, but there'll be some compromises made too. So our first actual meeting is next week via Zoom. And we used to meet in person prior to on our old committee for disaster protocols met in Colorado. Now we'll be meeting Zoom for the first time next week.
Okay. Well, I think we're at the end of our presentation today. You know, one of the goals today was to expose you to Holly, to give you someone who specializes really in the area of addressing your legal needs. We focus on the insured, she focuses on you. And so if there are other topics that you would like to have Holly address in the future, or other areas that you think are important, we would be happy to, consider them and, get Holly back out here again for you with maybe, the same panel or a different panel. Anything you want to say in closing, Chip?
Yeah, I'd like to say thanks everybody for coming to this. I hope all of y'all will go out there and get licensed in other states. I hope you will work with other public adjusters. I really encourage that. I think the people that do learn the tricks and techniques that other people do, because there's a lot more camaraderie. I've actually seen people have their public adjuster practices merge, and it's just amazing. And I'm, how much people I think enjoy working with others, especially if you're in a smaller shop, 1, 2, or 3 people. Getting to know other people in other parts of the country is fantastic, and there's no way you're going to be able to handle your own influx of cases in your own hometown if you have a catastrophe. So I hope you'll use this, if you aren't doing it, as a stepping stone to go out there and think and then do it. And then tomorrow at 2 o'clock, I'm going to have a brief 15, 20-minute discussion, Chip at 2 at Friday for just 15, 20 minutes on Facebook live stream. And we'll chat more about some of the big public adjuster issues that are coming up. And there's certainly some that I was just even sending some emails to some of you regarding a brand new lawsuit out there in Texas regarding public adjusters. So I hope to see you tomorrow at 2 o'clock on Facebook live stream. Take care.
Thank you, everybody.
Bye.
Thank you. Thanks so much.